what we'll do is we're going to start by talking about the Supreme Court cases that are coming most imminent, the Gonzalez and Tomnet cases. Evelyn's going to talk about that. Then Daphne will talk about the NetChoice cases, and then Jack will speak after. So why don't I turn it over to Evelyn to talk about the Gonzalez and Tomnet cases.
All right, thanks. Thanks, Nate. So I feel like my job is to be the newscaster who's like giving the preview of the Super Bowl, because this is coming up next week and it's a very exciting time. It's basically the Super Bowl for internet lawyers. And you've probably read a billion news articles about this at this point, with headlines like, you know, the Supreme Court poised to upend the internet. So I will sort of be brief and high level. But let's start with Gonzalez, which is due to be argued on Tuesday morning next week. So this is a claim brought by the family of a victim of the 2015 ISIS terror attacks in Paris. And the allegation is that YouTube aided and abetted ISIS under the Anti-Terrorism Act. Now, it's well established. We know that you can't sue YouTube merely because it has ISIS content on its platform at some point. That's the core of what Section 230 does. That's the whole job of Section 230. So what the plaintiffs are doing in this case is saying that there is at some point at which a platform loses that Section 230 immunity because it has recommended the content in question. So in general, you can't sue a platform for the content of somewhat third-party content on the service, but if the platform is recommending that content to other people, then it will lose its Section 230 immunity and can be sued. So the question is, what exactly is, if that's true, what exactly comprises sufficient recommendation, or where the line is, and that's extremely unclear, and I'm no doubt sure we're going to be talking about that a lot on the panel today. But basically, in this case, it's things like the up next feed on YouTube, where you've watched certain content, and the idea is that YouTube is feeding you these videos based on perhaps some signals that you've given it of what you've watched before. Then on Wednesday morning, we're going to turn around and hear Tumna that's being argued. Now, this is talked about a lot less in the press coverage that you've read, but to my mind, this is really where the rubber hits the road in terms of for platforms and the effects of these potential rulings. Because even if the platforms lose in Gonzalez, they will lose the procedural benefits of Section 230, which is not a small thing. Like that matters, that they have to go to court and defend on the substance of whether there's liability, but they won't actually be held liable unless there's an underlying claim for an underlying cause of action, and that's what Tumna's about. So this is materially identical facts. This case is a claim brought by the family of a victim of a 2017 terrorist attack in Istanbul, which claims that Twitter, Google, and Facebook aided and abetted terrorism by allowing ISIS on their platforms. And the allegation here is that Twitter did not take sufficiently meaningful action to stop ISIS by proactively detecting and removing ISIS-related accounts or posts. And this is, despite the fact that Twitter, Facebook, Google, all of them do have significant content moderation programs dedicated to finding terrorist content and taking it down, but we also know that they are not completely effective or perfect at doing so. And so the claim is that under the Anti-Terrorism Act, as amended by the Justice Against Sponsors of Terrorism Act, that there's an extremely broad definition of aiding and abetting an act of international terrorism, which again, I'm sure we can talk about the peculiarities of this particular statute or whether it is sui generis, and that sort of this generalized knowledge that there is ISIS content somewhere on your platform is sufficient to bring secondary liability for aiding and abetting ISIS's terrorist activities. Just a note about what weird vehicles these cases are. So in both cases, the causal chain is extremely weak. So in Gonzalez, there's no allegation that Google had any role in encouraging or committing the Paris attack, or that the Paris terrorists were recruited or radicalized through YouTube or used YouTube to plan or conduct the attack. And there's no sort of specific allegation of a particular video or a particular attacker that saw a recommendation. And similarly, in Tumna, there's no proof that the attacker in that case ever had accounts on Twitter, Facebook, or YouTube. And there's no identification of any particular piece of terrorist content that Twitter knew about, but failed to take down with knowledge. So it's sort of a very generalized knowledge standard. And again, noting that in both cases, platforms, there's lots of evidence that they did have moderation programs to do with terrorist content. So it's an extremely tenuous causal connection, which I think makes it particularly interesting and potentially scary. So we're going to go through the nitty-gritty throughout the panel, but I think I want to highlight what are two big open questions for these cases. The first is, what would count as recommending? And if the court does find that you can lose Section 230 immunity for some form of recommendation activity, that could be how the court defines where to draw the line is kind of going to be the whole ball game. So are we talking just about like, here's a terrorist you may know, or, the trending section, or there was a story yesterday about Facebook automatically creating pages for terrorist groups based on signals that it gets? Or is this like the entire news feed, or like all of TikTok, which basically is a recommendation algorithm? Like there is no TikTok without a recommendation algorithm. So how does the court define recommending or draw the line? And the big looming issue here is search engines, because there seems to be this thing in the air. Everyone agrees this shouldn't apply to search engines. Like search engines shouldn't lose Section 230 immunity when they recommend answers to you based on your queries. Like that would be terrible. We all like using Google, and some of us like using Bing now. So how do we protect search engines and the recommendations that they do based on what you request, but kind of get at this thing that some people feel uncomfortable about other kinds of recommendations? So that's the looming issue there. And then the other question I think that's really on the table here is, how much of this is about the Anti-Terrorism Act in particular, and how much of this is about generalized secondary liability? So, one outcome would be like, to me, Tumnah is a very scary case. To have secondary liability based on the facts in that case seems to me to be very expansive and quite scary. It's so incredibly broad, and we can talk more about that. It almost seems to be so broad that it seems kind of impossible to imagine that aiding and abetting based on just this sort of this generalized knowledge standard would be sufficient. But the way to lose well in Tumnah would be to say something along the lines of, yes, but this was the ATA, this is the Anti-Terrorism Act, and Congress intended to have this like super broad, expansive, ridiculously large form of secondary liability. It's international terrorism. We know from Holder that we don't sort of super really care about that kind of speech. And so it's okay in this particular case, but we're not going to go any further. The bad way to lose is to not have that, and then potentially open the door to all sorts of kinds of secondary liability in cases like, for example, aiding and abetting abortion or other kinds of statutes that you might see coming down the line. So that's the scary version of losing that case. And those are the open questions, I think.
Great. Daphne.
All right. So moving on from the cases about making platforms take down more user content to the cases about preventing them from taking down user content. The concern in Gonzalez and Tumnah, the cases that Evelyn just talked about, the ones that are pending very, very soon, from a lot of sort of free expression advocates or tech policy people, is that an adverse ruling here, a ruling that says that the platforms are liable for bad stuff in their news feeds or any ranked part of the platform, is going to cause them to go out and like way overdo it and take down all kinds of speech that's actually legal, but that just made their lawyers nervous or made their machine learning models nervous, or somehow raised any kind of legal risk for them. And we know from experience with other liability laws and with ways that platforms operationalize their compliance is that there is very much a tendency to overdo it and to take down lawful but controversial speech, or speech that has something to do with terrorism, but actually, is counter speech, but the automated filters can't tell that. We also know that there's a big concern about disparate impact from that kind of sloppy removal, where in the terrorism context in particular, you might expect to see disparate impact and way more unfair, improper removals affecting people who are speaking Arabic, or who are talking about Islam, or who are talking about Syrian immigration policy. So there's this sort of looming set of issues about taking down not just the illegal stuff, or not just the stuff that gives rise to these plaintiffs' cause of action, but also a bunch of other stuff. Enter the NetChoice cases, which we all thought might wind up going to the court this term, but now seem very likely to go to the court the second term, the fall term. These are cases based on laws enacted in Texas and Florida by legislators who were very concerned about perceived anti-conservative bias on big social media platforms. And so their explicit intention was to try to correct for that and to make the platforms stop censoring conservative voices. There are lots of quotes from the governors involved and the legislators saying clearly that is their intention. Both of the laws have some provisions about making platforms leave content up, and also some provisions about requiring new transparency measures, which has been a little bit of a sleeper issue in the case, and we might get to that later. But the so-called must-carry provisions are a little different in the two laws, and they're both long, convoluted, hard to read, poorly drafted laws. I don't think the lawmakers thought about a future of anybody actually complying. I think it was just really fun for them to draft these laws. So the Texas one, the key provision says that platforms can't discriminate on the basis of viewpoint when they remove or demote or demonetize or otherwise moderate content by their users. And I think what these legislators were thinking was, you can't discriminate against, Tucker Carlson, stop censoring conservative voices. But really, what it means to not discriminate on the basis of viewpoint, while this is somewhat debated on the details, but if you are leaving up anti-teen anorexia videos, then you have to also leave up the pro-teen anorexia videos. If you're leaving up the anti-suicide videos, you take down the pro-suicide videos. If you are leaving up the claims that the Holocaust is real, you also leave up the claims that the Holocaust is not real. So there's just this very grim array of consequences from that rule requiring viewpoint neutrality. The Florida law comes at this differently. It instead identifies particular speakers who are basically not allowed to be moderated at all. Platforms can't remove or demote their content almost no matter what they say. And this includes journalists, this very broadly, weirdly defined class of journalists or journalistic outlets, and political candidates, or anybody talking about political candidates. So if you are talking about a political candidate in Florida and you want to add, some defamation, some pro-ISIS content, some, the pro-suicide, Holocaust denial, all of that, you're golden. The platforms can't take down what you posted. Neither of these laws has actually come into effect yet, to be clear. So all of this is still hypothetical, yet racing toward the Supreme Court. So the platforms acting through some trade associations, one called NetChoice and one called CCIA, sued saying that these laws were unconstitutional, and very quickly got enforcement enjoined. And that's remained through some bumps and wrinkles, but that's remained the case ever since. So there hasn't been a moment when they're supposed to be trying to comply. The claims that they brought are basically three claims, 1.5 of which are surviving to the Supreme Court level. So a really interesting claim that's still parked down in the district court is that these laws violate the so-called dormant commerce clause, that basically by creating a situation where national and indeed global platforms have to apply completely different speech rules in every single state, that this is, violating a principle of which rules should be set by states versus set at the federal level. That question is not, as I said, it's parked back in the district court, so it didn't even make it to the appeals court level. The second claim is that these laws violate Section 230, this famous statute that Evelyn was talking about, and that is at issue in the Gonzalez and Tomna cases. That one, it's a little complicated what happened, but basically it didn't make it to the Supreme Court. The third claim, and the most important claim in many ways, is that these laws violate the platform's own First Amendment rights to set their editorial policy and decide what content they want to carry and what they want to remove, and what the rules are for discourse on their service. And that claim has a lot of support in Supreme Court precedent. We know that cable companies have First Amendment rights even when they're acting just as aggregators of third-party content. Not insurmountable First Amendment rights, but they have them. We know that parade operators have First Amendment rights to decide what parade participants to kick out, even if they've kind of never expressed any editorial intent in the first place. So the platforms, I think, are very on firm legal ground based on everything that's happened before, but they're teeing up this question to courts that would like something different to happen. And so what happened at the circuit court level was that the Florida law was struck down as a violation of the platform's First Amendment rights on the basis of these cases I just described. But the Texas law at the circuit court was resoundingly upheld in an opinion that is, I think, kind of like gleeful and exuberant in its ability to disregard precedent. But maybe that glee and exuberance is warranted because maybe the Supreme Court is going to look at this the same way that the Fifth Circuit did. They have every ability to move away from that precedent. And so assuming these cases get to the Supreme Court, it is that First Amendment issue that is teed up. And the reason I said there are 1.5 issues is that there are some statutory questions about CDA 230 that are kind of embedded in how the court is going to interpret the Texas and Florida statutes. That's where things stand. The court asked, they didn't accept cert, agree to review these laws, but they did ask the Solicitor General's office in DOJ to advise them on what they should do, which usually is a strong sign of interest. It's also just very likely, given there's a circuit split, it's a massively important topic. Presumably they will take these cases.
Wonderful. Let me just say something to the several hundred people who are joining us online. If you have questions, put them in the Q&A and they will be forwarded to me after the sort of opening comments. Let me turn it over to Jack.
And if they have questions for the justices, they should also send them to you.
Just send them to me. Yeah, I'll post them on
Okay.
North Capitol Street there.
There we go. So I'm going to talk a little bit about the First Amendment issues in NetChoice. Then I'll say just a few things about Google and Tomna. So if you step back and you think about it from a distance, what NetChoice is about is the fact that as soon as you have these large platforms that publish user-generated content. So as soon as you have that, which you didn't have in the 20th century, you're going to have free speech conflicts. You're going to have the free speech interests that Daphne identified, the editorial, curational interests, the right to select who you publish, and you're also going to have the free speech interests of the actual end users. So they have free speech interests too. And so what NetChoice is about a conflict between free speech interests. Now, these conflicts existed before in the 20th century, but basically people didn't pay much attention to them. So for example, if you wrote a letter to the editor of the New York Times might not publish it. And people said, well, gee, I guess they didn't publish it. But in those days, that was not considered to be a serious First Amendment conflict, although in the context of broadcast media, this actually did go to the Supreme Court in about 1971. The Supreme Court said, no, the broadcasters have the First Amendment rights here, not the people who would like to broadcast on the networks. So essentially, this is really a product of the 21st century, pervasive free speech conflicts between platforms and end users. And that's what these cases are really about. Now, the problem is that American First Amendment law is just not well designed to deal with conflicting free speech claims. Either one side has a First Amendment right, or the other side has a First Amendment right, or maybe neither has a First Amendment right. But it's really hard under American law to make this work. If you're outside the United States and you live in a country that has a doctrine of horizontal effect, in which you can actually apply constitutional norms to private companies, Well, that's a different world. And there you might have to engage in a certain kind of balancing of free speech interests. Also, you might need a framework statute to basically do the balancing, and then you would just apply the framework statute. But that's not the United States, and that's not the United States way of dealing with free speech issues. So as a result, the way in which you have to resolve these conflicts, if you're interested in protecting the free speech rights of the end users as opposed to the platforms, is you have to come up with some kind of theory. And there are a bunch of theories, and Texas chose one, but I'll go through the list of the theories for you. So one is you can declare the platform a common carrier. That's like a railroad. I have some freight. Here are my chickens. Here is my wheat. You must carry my chickens and my wheat. Right. So it's just common carriage. That's one model. Another model would be public accommodation. Hi, I'm entering the Starbucks now. You must serve me. Right. So you must let me go in the Starbucks and order my coffee. All right, that's a little different than common carriage, a different model. Generally, public accommodation laws are about who you are, your identity, but you can't discriminate on the basis of various categories. That's what public accommodations laws are basically. Whereas common carriage is basically, if I pay the freight, you take my chickens, you take my wheat. Also, there's another model, which is also in public accommodation and in common carriage, if you act really, really badly. So in other words, you're riding on the railroad and you start punching the other passengers, or you go into the Starbucks and you start throwing the chairs around, they can throw you out. But that's largely, the analogy to that would be largely civility rules. You see, in other words, behave nicely toward other people. It wouldn't be telling people that the moon landing was faked, or that, you know, the best way to cure COVID is take a particular drug used for horses. That's just not what the civility rules for public accommodations and common carriage are about. So you wouldn't be able to deal with those kinds of issues. But from the standpoint of protecting end user speech rights, yeah, that's the whole idea, is that once you're in the Starbucks, you know, they have to serve you. Once you put the wheat on the railroad, they have to take you to the next place. A third model, which is not loved at all by most conservatives these days, is actually closer to what Florida was trying to do in its statute, and that is Red Lion. That's the idea that if you are a broadcaster, your business is affected with a public interest, and therefore the government will require a bunch of public interest obligations, among which are equal time. So in other words, if it gives access to an identified candidate to use the facilities of the broadcaster, well, then you have to give equal time to those other competing candidates. There's also rules under public interest about relatively cheap cost for advertising, and there's also rules that say that if you're a political candidate and you advertise, they can't refuse to carry the advertisement even if it's false, and would cause all sorts of problems otherwise. So in other words, it's like a little carve out so that you have to carry the advertising of political candidates. That actually is the closest to what Florida was trying to do, but it's very important to understand that for most political conservatives these days, Red Lion are two dirty words. They don't like Red Lion, they think it's really bad, and they identify it with the fairness doctrine, which conservatives generally don't like because they identify that with preventing conservatives from talking on the airways. It's also true that this broadcasting model requires some kind of regulatory hook by which you can justify the regime. So the traditional rule for broadcast was that broadcast spectrum creates problems of conflicts, right? People trying to broadcast on the same, on the same wavelength. So as a result, frequency. So as a result, you have to zone it. And once you zone it, you decide you want to license it. And then once you license it, you require as a condition of the license a set of public interest obligations. That doesn't seem to work in the context of platforms. You don't have the same set of problems. And so it's not clear how the Red Lion model is going to work in this context. And then another one, which is what Texas's law was trying to do, is a must-carry theory. And the must-carry theory is a kind of watered-down common carriage model in which you say to a cable company, you have to carry the broadcast signals of local broadcast stations. The Supreme Court has held in a couple of cases that that should be treated as a content neutral time, place, and manner rule. although there are very plausible arguments that it is not a content neutral time, place, manner rule, but the Supreme Court has so said, and it's justified it on the grounds of competition. Justice Breyer justified it on the grounds of democracy, which I think is actually a sounder way of understanding what's going on. But in any case, those are the models. What you get in the NetChoice cases are a kind of bizarro version of must carry. That is that's the Texas law, and a bizarro version of Red Lion, which is the Florida law. And these statutes are not well drafted. They have lots of holes in them. They have lots of exceptions in them. Daphne can give you more details on it. But basically, because of the way they're drafted, they're so poorly drafted that even if the court were to get to the first level and say, oh yeah, we think common carriage is a real idea. We think public accommodation is a real idea. We think that we could stretch Red Lion to this. You would still face all of these problems of over and under inclusiveness. And so you would still have First Amendment problems. This is assuming a court that's applying the existing First Amendment law. Remember, they can always change the law. There are other issues as well. There are preemption issues that Daphne mentioned because of Section 230, and there are also Dormant Commerce Clause issues, which, if they lose, they have to go back to Dormant Commerce Clause because it's like a serious Dormant Commerce Clause problem. Even if this were done as a federal statute, so in other words, not at the state level, but at the federal level, you still have problems because these are global companies. But all the more so when you think of each individual state having its own rules for taking things down and leaving things up. And imagine state A says, you must take this down, and state B says, you must leave this up. And what are you going to do? And Daphne, correct me, does the Texas statute say that you can't actually leave Texas?
It says that people outside of Texas who do business with Texas have a cause of action. So you're somehow, the platforms are supposed to apply these rules to people outside, here.
Right.
And it says that it's prohibited discrimination to discriminate based on geographic origin. So like geo-blocking Texas, in theory, itself violates the law.
Right. So this is very troubling, I would say. I mean, Supreme Court's never taken a case on geo-blocking, but this is a very troubling claim. That is that you have to stay here and you have to serve our citizens and you can't leave. And you can't treat us any differently than any other place. So in fact, Texas is trying to expand its reach, actually not just to other states, but globally. So there are other provisions in the NetChoice cases, which I will let Daphne talk about. They're very important. They have to do with the issues of transparency. They have all sorts of unintended consequences, but I'll let Daphne tell you what those are. But I think they're really important. And it's the sleeper issue, as you said, in the case. Now let me just turn a little bit to talk about Google and Tamna. On Google, I just should disclose that I was part of a team that did an amicus brief on behalf of Representative Cox and Senator Wyden, who were the original drafters of Section 230. So what I am about to say does not reflect their views, although it's close. It's close, but actually there are some differences. And we tried very hard to write a brief that really reflected what they wanted. They thought that the law was intended to say. The way I would put it, which is not the way the brief puts it, but it's close enough, is there are really two questions to ask. One question is this content, these ISIS videos, is this content that Google produced itself? Is this content that Google helped produce? Is it content that Google basically contributed in any way to producing? Okay, that's step one. The answer is no. Google did not try to produce it in any way. It did not contribute it to any way. This is ISIS. These are ISIS videos. The second question is the cause of action that is being brought here a cause of action which relies on the fact that Google published these videos or communicated them to other people? And if the answer to that is yes, then Section 230 should apply. So in other words, from the standpoint of the brief that I worked on, this is a relatively simple case. It's not a difficult case if you just follow those two steps. Now, let's talk about the complications. So what the petitioners would like to do in this case is they would like to drive a wedge between speaking and publishing on the one hand and recommending on the other. So in other words, yes, we could agree that if you merely published or spoke, Section 230 applies, but you did something different than publishing and speaking, you recommended. In my view, The problem with that attempt to drive a wedge between these ideas is that it is really hard. This is really what Evelyn said. It is really hard for some social media companies to make that distinction because there's just so much content that's going into the database. And in order to produce a feed of anything, you're going to have to engage in recommendation systems. That is to say, the distinction between a recommendation system and a publishing system vanishes for a large number of different models of end user. I could design a social media company that actually never recommends anything and just gives you reverse chronological feeds. Whatever comes in, that's the next thing you get. You can design something like that. I mean, it wouldn't be very enjoyable. It wouldn't be something that consumers wanted, but you can design it. But the central idea of Section 230, and this is really a point that Cox and Wyden emphasized, is that it was designed to be technologically adaptable. It was designed to be an immunity that no matter how the systems would develop over time could still be applied. And the attempt to drive a wedge between recommendation systems and publishing systems basically is not faithful to this idea of being technologically adaptable. I should just point out that even at the time that Section 230 was written, when you had just bulletin board systems and you had the very earliest kinds of sites, you had curation, you had recommendations. They weren't done through algorithms, they were done by hand. But the people who drafted it knew well that there would be curation and recommendation systems at the time. So that actually isn't new. But I think from my perspective, the most important thing is to interpret the immunity in such a way that it can be adaptable to the ways in which technology is likely to innovate. So this is a pro-innovation argument, if you will, for interpreting it this way. And I think that's really what Cox and Wyden were after. Now, I also want to say that this has nothing to do with the question of whether Congress might, in its infinite wisdom, decide to amend Section 230. Completely different set of questions. It's a question as to what this statute says. And another question, completely different, is whether or not there might be some particular causes of action against a platform that don't turn on its publishing content or speaking content to other people. Again, not this case. And indeed, there will be cases in the future that raise these kinds of issues. There may be independent duties on the parts of platforms toward their end users arising out of their collection of data, for example, which may have knock-on effects on their recommendation and content moderation systems, but that's not this case. And I would hope that the Supreme Court understands that this case can be disposed of in relatively narrow terms, but will they? Well, who knows? Last thing I want to say about Tamna. You were talking about secondary liability. I'm an old torts professor, so I think about it as, is this a negligence case? Or does this require, specific intent? Or is diffuse knowledge sufficient? My view is that if you interpret the ATA to require mere negligence, that is, yeah, you're kind of aware that there's terrorist content on your system. You have an algorithm that tries to get rid of as much of it as possible, but the algorithm has error rates, and your programmers have error rates. They can't get everything, and as a result, some of the stuff sneaks through, which at best would be a negligence claim. Is that sufficient to be aiding and abetting? And my answer is that can't be the right answer. A mere negligence with diffuse knowledge can't be sufficient under the statute. And I think that's what the case turns on. Of course, the real question, and the one you guys probably want to know, is what will the justices do? Mm-hmm. And here, I must tell you something. I am terrible at predicting the votes of the justices. I am terrible. You might as well just spin the big wheel, right? It's also important to understand that the justices have ideological priors in these cases that point in opposite directions. Some of the justices really don't trust large tech giants and would very much like to stick it to them. Others of the justices are very strongly believe in a very strong libertarian First Amendment and rights of platforms that fall into it. And so that would take them in the other direction. Some of them are textualists. And so the kind of argument I just made about Google versus Gonzalez, which is look at the text dummy, should appeal to them greatly. But some of those justices also don't like big tech. very much. And so that'll push them away from a sort of textualist reading. So I throw up my hands in amazement and wonderment and suggest that I have absolutely no idea how these cases will come out.
Well, on that note of humility, why don't we give Evelyn 10 minutes or so to pick up on that if you'd like, and then Daphne, and then I'll ask some questions.
Sure. Okay. So I mean, I think the big interesting question that we're trying to drill down on today is this overlap question, this potential conflict question, because as Daphne teed it up, introducing these comments like the Gonzalez and Tumner cases about liability for leaving content up, so incentivizing platforms to take things down, and the NetChoice cases are about liability for taking things down, so incentivizing platforms to keep things up. And there's this, when you say it like that, that sounds kind of in conflict. And so, I mean, I'm definitely curious for Daphne's thoughts on this. My reading of the statutes and the potential outcomes here is there's no necessary direct technical literal conflict. So you could have a situation where, let's say, so the conflict comes if the platforms lose in all cases. So they lose in Gonzalez and they're liable for the content that they recommend, and they lose in NetChoice and they're liable for content that they take down. Now, it is certainly true that moderating terrorist content will often almost always involve viewpoint discrimination. You have to take things down based on the viewpoint that they express, and so that would ostensibly be a breach of HB 20, the Texas law. But Texas has a carve out for unlawful content. So it says you are allowed to quote unquote censor, as the statute calls it, censor, or as we might call it, moderate, unlawful content. And that's defined to include a tort. So if this content becomes tortious, sorry?
What about Florida though?
What about Florida? Well, yes. So now you have a situation in Florida. Well, so there's no express carve out for unlawful content in Florida. So if a candidate or a journalistic enterprise posts terrorist content, on the face of it, you would think that there's no, but I would think that a court would read in an exception for unlawful content, that the platform would be allowed to take unlawful content down, because you can't have a situation where they would read down the statute. But in some ways that makes it more dangerous, because the court could go along and say, this is okay, we can resolve these cases and have this situation where they're not directly in conflict. Well, we've done such a great job. We've said that we have resolved Gonzalez, resolved the NetChoice cases, and we're fine. But in actual fact, the practical, that legal situation in practice is an absolute nightmare and impossibility for platforms, because what that says is you have to get this exactly right. You have to take down the unlawful stuff and no more. And the moment that you take down something that would not help an aiding and abetting claim, would not introduce tortious liability, you're now subject under the Texas statute for a claim. And I mean, there's stats in the Gonzalez Google brief about the level of content that we're talking about here, but every day users generate around 720,000 hours of new YouTube content, and over 500 million tweets. So you just can't get every single call on that volume of content right. So this idea that there's no technical conflict because all platforms just need to get it absolutely right is an impossibility and not a feasible outcome. But in some ways it's more dangerous because the court could think, oh, it's okay, we can resolve this in a way that there's no direct conflict. The other thing to note about that outcome is it's almost certainly the outcome would be the opposite of what Texas or Florida want in these cases. So the as Daphne laid out, the motivating desire of these statutes is that platforms over-moderate, they take too much stuff down, we really want them to be more hands-off and let the marketplace of ideas run free. But if they become liable for, so let's take the Texas law, if they become liable in Gonzalez for content that they recommend, but they also can't take things down on the basis of viewpoint under Texas, they're going to try and define broader categories that are not viewpoint based, but are maybe subject based, or use other indicia to take things down that are going to be broader than viewpoints. So instead of taking down, terrorist content, they may take down, we've seen this example for small platforms, but like take down any content in Arabic, for example, because we don't have the sufficient fine tools to work out which Arabic content is, at that level of scale. We're just so scared of liability that that's the choice that we're going to make. Or, for example, take down any violent content. But that might include, for example, we know this from YouTube, evidence of war crimes in Syria and things like that. Really important democratic content. Any mentions of ISIS, which might include counter speech or reporting or journalistic content, which then you run into problems in Florida. But basically, what it's going to incentivize platforms to do is to take down more content than they would otherwise, because they don't want to engage in viewpoint, or they can't engage in viewpoint discrimination, but they want to avoid the liability that they're exposed to under a loss in Gonzalez. So there's that quirk there, that the legislatures aren't getting the outcome that they're hoping for. I think, in terms of like what exactly, how to moderate in this situation, I think also depends a lot on the construction or what the court says. And this so much is up for grabs. Like we've talked about this really difficult problem. If the court wants to find liability for recommendations in Gonzalez, about how. And here the parties' briefs actually aren't as helpful. Like there's not good guidance for the court, I think, in any of the briefs, and we could talk about, and Daphne could talk about that in more detail as well, about some of the suggestions that have been put forward. But there's not a lot for the court to work with in terms of coming up with a really workable standard. And so I don't know if what a loss in Gonzalez looks like, what the standard would be that they come up with, but that will change how platforms have to moderate. So again, are we talking about they need to turn off certain particular kinds of features that are really aggressive recommendations, like, here are some people you may know, and that the liability for that is too scary, so they just turn off those kinds of recommendations? Or is it something like we just all need to go back to chronological feeds? Those are very, very different outcomes. The other thing I think it's worth just sort of, I'll finish on this point, is that this is a really the politics of this of these cases in this court at this moment are particularly weird and up for grabs. So Jack was talking about the Red Lion cases and the conservative sort of dislike of those kinds of laws. But what we're seeing is these laws in Texas and Florida that are now anti-private discretion over editorial choices, that is really kind of backwards from what the dominant conservative free speech First Amendment ideology has been for a long time, and indeed was in Halleck, which is 5-6 years ago. So as recently as that, this has been a really big quick turnaround. And so it's this really unusual, I mean, it's very exciting for First Amendment scholars and people in this space, because it's this unusual space where this is highly consequential, this is hugely political, so much is up for grabs, and the outcome is especially uncertain. This is not a case where we have really clear partisan divides on the court that we know 5-4 how this is going to come out. There are certainly some justices, and again we can talk about this more, who have made their feelings pretty clear, but how this comes out in terms of what coalitions we see, in terms of where conservatives and liberals might find common ground, I think is extremely up for grabs, which makes it both exciting and potentially more terrifying.
I have so many things to say. So I will speak briefly to the transparency point that Jack raised, and then I want to respond to a couple of things Jack said, and then I'll talk some more about overlap points, and I'm going to do it all really fast. So on transparency, what has happened so far in these cases? So the transparency mandates are like publish regular transparency reports, notify users when their content has been taken down, a bunch of other things, but kind of for the most part, kind of standard platform transparency asks. So far, the platforms say, what? we're like newspapers. You can't compel newspapers to disclose what happens in their editorial decision making or why they rejected a letter to the editor. That's crazy. And the states say, no, you're just like any vendor of consumer goods, and we can make you put labels on your products for consumer protection purposes so they understand what the product is that they're getting. And so far, both courts bought into that reasoning from the states. And in very brief analysis, which is understandable because the parties barely briefed this, they said, no, we're upholding this on following the state's theory and applying a case called Zouderer. My worry here, and I have a big pending paper on this, is that like, there's actually a problem that really lies in between those two things. If you look at the Zouderer cases, the questions about speech, about the speech rights of the companies, are things like, oh, if we make you put a health warning on your cigarette package, are we forcing you to carry a message you disagree with? Or are we displacing the speech you wanted to put there? Neither of which are really a big deal for purposes of the platform transparency stuff. Or when there's when the companies that have been forced to do disclosures have said, this is really burdensome, this is really hard, like, don't make us do this. For example, there was a case about forcing meat packers to label the country of origin for meat, and the meat packing trade association said, this is going to make us have to rework our whole infrastructure. The court was like, that isn't speech. You know, we don't care if we're making you change your underlying operations. But here, if the burden or the enforcement process or pressure from the AGs about, you know, from Ken Paxton in Texas about platforms transparency, if it does cause them to change their underlying practices, which I absolutely believe it will, then it's actually affecting the editorial enforcement and the content moderation, and it's also affecting the speech rights of the users who are being affected by that. So there's just this issue about what it means to impose a burden or an enforcement process that changes what the business does, that we don't care about, or the First Amendment doesn't care about from meat packers, but it definitely should care about for platforms. So that's the thrust of my, and that nobody's briefed this or thought about this so far. So it might just go to the Supreme Court, you know, with that question being raised for the first time. Going on to some other points that Jack raised, I want to kind of complicate the idea that user speech rights and platform speech rights are always in tension. I think if we think of users as like always wanting the free speech mosh pit where they can say as much as possible and like shout each other down or whatever, then those users who want that, their interests are in conflict with the platforms that want to moderate speech. But if we think about users who are like female journalists sick of being harassed and like brigaded and threatened and doxxed, and who stop speaking on Twitter because of that, you know, they have a speech interest that maybe is aided by moderation that stops people from harassing them. Or you could also think about users who want a curated feed. They want to go to their news feed and not see a bunch of hate speech or disinformation. You know, they as readers want the curation. So I think the way Americans tend to think about the First Amendment, those are kind of lesser interests. Like we side with the mosh pit guys, but I don't think we should have to. You know, I think those other interests should be relevant. And part of, I think the right way to think about it is there another place to go where those other First Amendment interests are vindicated better? Or are we stuck in this situation where there's only going to be one super concentrated place for discourse, and then the government's going to set the rule, and the rule is going to be the mosh pit? Like, we're going to force common carriage on everyone, which is kind of the approach that
I just want to say I totally agree with this, and that's why my view has always been that what you need to have is many different platforms, as opposed to a relatively small number of global platforms.
Amen, brother.
Because you need different rule sets. This is very old internet law. This is like at the very beginning of the internet law.
Everyone's forgotten. You have to tell them again.
Oh, all right. Well, so a very early idea of the internet was there would be things, they didn't call them platforms in those days. There would be different spaces that would be ruled by different norms. And you would basically move to the platform that had the norms you liked. And those norms might be highly libertarian, but they also might be protective. They might be civility rules. They might have rules about how to work well and play well with others. And this is one of the oldest ideas, actually, in the legal arguments about the internet, and it has been forgotten. But it's only possible if you don't have a world in which 2 or 3 very large companies really control most of the online speech. You have to have lots and lots of them.
But don't we live in that world though? And so I want to get back to your point. I mean, you want to go to 4chan, you want to go to Reddit, you've got that option. You want to go to Mastodon. Sure, the point here is that you don't want to go there because that's not where the people are. But from a free speech standpoint, right, as to whether you have the ability to engage in mosh pit activities, there are plenty of mosh pits on the internet. You know, if you want to go there, yeah, my friends might not be there, but that's, tough luck.
I think we have to have a whole session on middleware in order.
We'll
that
talk about that.
question.
And for the folks at home, we have a great project on that. All right, finish up what you're saying.
Yeah. So on common carriage, I just want to flag that all these arguments about how platforms are common carriers were not upheld in any of the circuit court decisions. So in theory, they shouldn't really be at issue here. But the cert petitions or the cert briefing from the states really emphasize these common carriage arguments, and they're doing it in part because they know that Justice Thomas is interested in them. So, they have, nobody's upheld this yet, but it presumably the courts will address it. I think that Jackie, you said that Republicans don't like Red Lion, and that's certainly the case historically. But I feel like they're backing themselves into liking something like Red Lion plus Pacifica, to thinking there should be a situation where the state says, hey, platforms, you have to carry speech. Oh, okay, but you don't have to carry porn and you don't have to carry extreme violence. And, and the state identifies this new distinction between lawful speech that is favored and that platforms are compelled to carry, and lawful speech that is disfavored and that platforms may choose to take down if they want to. And that's, it bears some family resemblance to things that the FCC has done in the past with broadcast and cable, but it is a set of rules for all of us and our day-to-day speech on platforms. Like, it is wildly different to take that kind of state-imposed new speech rules and make it part of everybody's daily life. I brought this up in a panel with FCC Commissioner Brandon Carr, and he was like, oh, yeah, that sounds okay. Like, he embraced it. And then his example of what platforms, of course, should be able to take down was profanity. So there's this alternate future that's interesting and scary. On the overlap issues, I think Evelyn did a great job explaining the take it down versus leave it up conflict. There's a possible future where the platforms lose both cases. And if they lose in the must carry cases based on a theory that Eugene Volokh has put forward, they would lose the ability to decide what they host, but still be able to decide on how to rank things. So they're stuck being a common carrier for hosting your Facebook account, but nobody can see it unless they navigate to your page, something like that. But then if they lose in Gonzalez, it becomes much harder for them to do content moderation in their ranking and ranked features because of fear of liability. And so that tends toward this world where it looks more like 1980, there is something like broadcast TV, that's the ranked features that are vetted by lawyers and don't have any voices from the margins, whatever. And then there's the common carriage, kind of like the phone companies or something, where everything's there, but you can't find things and it's not ranked and organized. So I think that's one of the really interesting overlap points to explore.
So I want to, we've got a lot of stuff on the table here. I want to try and focus a little bit of the discussion this way on. Let's start with the Gonzalez and Tomna questions, which is there, since it seems everybody feels that the plaintiff should lose in this case, if I'm not misreading you all. What would the platforms have had to do to be liable that they didn't do here? So if the favoring of the algorithmic recommendation of some of this content wouldn't be enough, if, as is alleged in this, some of the sort of nexus perhaps with advertising and how they make money off of where they place advertising isn't enough, is there anything apart from the, Google saying, please, Google tells you to join ISIS, right? What would they have had to do to maybe, under sort of your view of the ATA, say what would they have had to do to be liable here that they didn't do, and consistent with Section 230, either you or Evelyn, and then Jeff.
So I think there are a bunch of scenarios that aren't presented in this case that are where the difficult line drawing lies. So, if Google was saying, hey, terrorists, please upload your content, trying to induce them or convince them or persuade them to upload.
Them in particular, though, right? Not just everyone.
I don't know. I mean, this is kind of like the facts of the dirty.com case where it was a particularly nasty guy urging ugly gossip to be uploaded, and he prevailed in his 230 defense. But there's a line there that's interesting, but nothing like that happened in this case. There's also there's this question about Facebook doing racially based or gender-based targeting of ads for housing and employment and credit. And the claim there, which I think is probably right, is that that's not immunized because these were lawful content in the first place. It's just a housing ad. And Facebook introduced the illegality through its targeting. That also is quite different from this case, but it's another line to approach. And then there's this scenario where so I used to be the Google web search lawyer, just full disclosure, but if Google pairs a snippet that says convicted axe murderer and then has an image that's Nate, and actually the underlying page did not pair those two things, so Google's creating the defamatory meaning, maybe that's a different line, but none of that is what this case is about.
But Evelyn, going to I think you put a sort of a good scenario when you were saying people you may know, right? So, hey, I'm just terrorist curious, but Google or Facebook seals the deal. Not enough, you think? You still should have Section 230 immunity. What else would they have had to do? That does it have to be really personalized?
So I think there's perhaps two axes along which you could differentiate the platform's conduct in this case, or in these kinds of cases. So the first might be the level of recommendation, the level of is this just in the newsfeed kind of ranking? Is this just people you may know, or is this up next, or is this videos recommended autoplay feature? You can see sort of a whole range of aggressiveness of pushing this content towards you, and then the other axes along which you could evaluate is the level of personalization and targeting. So is it a generalized this is we're taking general signals based on what's popular or not on our platform, or are we taking the user is expressing sort of certain interests and proclivities, I guess, and we're going to go and find content that matches those proclivities and match those users. So I guess and then of course there's the level of knowledge, which is what Jack was talking about. I think it's the level of knowledge here that makes these cases particularly concerning and scary.
Yeah, so let me give you I want to know how you feel about this. So person walks into a Barnes and Noble and says, I need some help finding a book. And they say, well, what are you interested in? He says, well, I'm really interested in terrorism, and especially international terrorism. I mean, I just can't get enough of international terrorism. I'm international terrorism curious. And the clerk says, oh, fine. Well, here's ours. No, can you really show me the books on international terrorism? Oh yeah, these three are the books we have on international terrorism. So he goes, he gets them, he gives them the MasterCard, he signs it up, and he walks out. Is that aiding and abetting?
No, I don't think so. But I wonder whether
But why is it not aiding and abetting?
Yeah, no, I mean, I understand, that's sort of where I was pressing, like, what would it take? And is there something different in the social media world where you're effectively, it's not just exposing people to speech, but it's also these kinds of groups and interactions, and then putting yourself into a community. You know, and you've thought a lot about freedom of association online as well.
All right, so let's have.
And we can spin the Barnes and Noble thing, so it's like that also. And I understand, maybe the answer is none of this that they should be immune from all that. But what would they, if ultimately that's what we're saying, is that
Well, here's a more troubling one. Okay, so I sign on to OpenAI, I go into ChatGPT, and I say, please write me an essay on the most important works on how to be an international terrorist. And ChatGPT dutifully writes the essay and gives you a bibliography. I mean, you can ask ChatGPT. Now it's Google's speech. I mean, Google has produced the content, or not Google, but it's OpenAI.
There, but
yeah, OpenAI has produced the content, and of course, the merger of search with AI upends all of the assumptions we've been making so far about how to think about it. Because now you can no longer say, no, we didn't produce any content.
Mm-hmm. Well, so what do you think in something, is 230 prepared for that?
230 is not prepared.
Yeah, I don't think so. I mean, I think that we might need another law on that.
But you're smiling because you've already thought about this. No. You don't have an opinion on it.
She asked ChatGPT and was not terribly helpful in your terrorist ambitions, I guess. Is
Yeah.
what that
But I do have an opinion on this knowledge thing. Like, I think as a matter of policy, like if you're writing platform liability laws from the start, the point where you more want to put the legal liability on the platform and a duty to take things down is when you think they can do a good job. Like if there's a situation where you think they can recognize the illegal stuff and not go terribly overboard taking down other things, then putting liability on them starts making more sense. And that's why they do have liability for things like child sexual abuse material, which is highly recognizable, highly dangerous. There's not this, big margin of political speech next to it that's going to come down. Terrorist content is like the opposite of that, because there is so much adjacent speech that is core political speech. And there are so many things that automated filters that are supposed to detect terrorist content will catch that are actually news reporting or counter speech or academic discussion. So, I think terrorism just is not plausibly in this category where we think there's such capacity for platforms to do a good job. That we would want to put the liability on them in that way. But 230, there's not really like an avenue through 230 to get to that conclusion anyway. That's a pure policy consideration.
So I want to go to the NetChoice cases and ask a similar kind of question. But let me just ask one last thing on this, which is the role of monetization and advertising, because that does surface in some of the briefs. Suppose that YouTube was that ISIS was a creator that got money from YouTube because it was putting up content that then was radicalizing these folks, but that then they were literally Google's paying for it at that point. Does that change anything else?
So I think most people have like the moral intuition that if you're making money from something, you should have more responsibility for it. And I think that's part of the reason why all of these, Google and every other company that does ads there are more restrictive policies for content in ads than there are for content that ordinary people can speak and share. And it's, in part because of that intuition. But in terms of just law, I mean, we have case law where the Drudge Report case where AOL not only was paying Matt Drudge for his defamatory posts, but like had all kinds of rights to edit them and the supervisory role and still got immunized. So I don't think the money matters as a matter of law. I can't remember what did the Ninth Circuit say? They had some weird reasoning, but maybe it was just on ATA and not on 230 that they did. Yeah.
But I just want to sort of pick up on because I think what you're reflecting in your last two questions, Nate, is like, okay, but there's got to be some point at which something like these platforms, like there's got to be a point where they're just doing something so bad that we want to put liability onto them, like where they're pushing it so hard or to so specific or they're taking money or something like that. And I think a lot of people share that intuition, including, some of the justices. I guess I would say, I mean, first Daphne's point about, what the law, like the law versus the policy, but also, what institutional competence and where do we want this decision to be made and how should this decision to be made? And there are long-standing debates about Section 230, as we all know. That's why the court's taken this up. It's never done it before, but it's obviously clearly interested. It's like everyone's talking about Section 230. We want to talk about Section 230. But maybe Congress should be the one that is we're talking about recommendations, and where is the fine line between this kind of recommendation and that kind of recommendation? And these are like technical questions that need like specific wording. We also like the pace of change. Like these cases are about content moderation practices in 2015 and 2017 that are now at the Supreme Court in the year of our Lord 2023. And the terrorist content moderation is like completely different to what YouTube and Twitter were doing back at the time of these attacks. So I think that in terms of like whether courts are a great way to be getting to these policy issues that you are clearly expressing disquiet about, I think if you are of that view, but Congress and legislation might be a better way of fixing those concerns, addressing those concerns.
Yeah, especially with respect to the question of advertising. It just seems to me that if you want to carve out advertising, revenue generation models, yeah, you can do that statutorily. The language of the statute doesn't really give you a hook. That's the problem.
So I was pressing you all to think about what Google or YouTube would have had to do to run afoul here and create liability. Now I want to ask you, if you were advising Ron DeSantis or Greg Abbott, what would you tell them? And so can you envision a properly drafted, there's lots of problems with these laws, you all I think expose that. What would they have had to do to or could they do anything that would regulate, say, Google and Facebook, and the degree to which to prevent either content moderation practices or algorithmic ranking that would discriminate against, say, Republican speakers? Is that something that even that phrasing it that way, that there's nothing that they could do consistent with the First Amendment, or could there be a properly drafted law that would try to get at this concern that Republicans have about bias?
And you're talking about, it's a federal statute now. So you're
leave outside the Dormant Commerce Clause stuff or whatever, but either federal or state, really. Now, could they? Is this just a dead end that states cannot, that state actors are not able to protect against ideological bias from these giant corporations, because that is necessarily viewpoint discriminatory and for Tornello-ish reasons or whatever. But that is that what you're all saying, or is it that they could have done this in a more narrow way that would have appropriately prevented against this kind of bias?
Well, this will not be satisfying. And if you ask me to give Ron DeSantis advice, my advice would be very different. I'd say stop picking on Black people and trans people.
Mm-hmm.
That would be my advice to him. But you're asking me about telecom, so I'd say that that you could do something like Eugene's proposal, but Eugene's proposal doesn't get Governor DeSantis what he wants. And it's also
just so people understand that Eugene Volokh, his proposal, as we've mentioned before, is that you can't knock people off the platform, but that you can algorithmically rank them based on viewpoint.
Yeah, I mean, Eugene reading First Amendment cases, much as I do, says, well, yeah, you can put it in the database. A big old database is what a social media company is. But once they start engaging in ranking and recommendations, with that, they have First Amendment rights to do that. And so Eugene offers them a meal, which is a stone and not a loaf of bread. And you could justify the proposal that you have to host based on common carriage models. Of course, you could do that. But that just brings me back to my idée fixe, which is what DeSantis should do is DeSantis should invest in the creation of turnkey software systems for lots of people to create social media companies, and also invest in software systems that would allow them to connect with each other so they could create a kind of Fediverse, a version of a Fediverse. And he should also invest in the creation of a separate industry that deals in content moderation, which would allow people to basically hook up these federated systems with the content moderation of their preference. That's what he should do. It's very pro-free market. And so I would try to appeal to him on those grounds. I don't think he would listen to me because I don't think this is about protecting free speech rights. I think this is about prosecuting culture wars.
Do you think that there's a difference on the Eugene point, because Jack was saying that, I mean, because you've written a piece about regulating amplification and that it's not as easy as people think. But this is kind of the flip side of that. Is it really the case that allowing people to just appear on, have a Facebook page is something that could be protected by law, but that algorithms are so core to the platform speech rights that then you can't regulate those?
Maybe. So Eugene and I had a lot of back and forth on this when I was writing my amplification and its discontents piece. And I kind of think there are other parts of the case. You know, he wrote this earlier article commissioned by Google saying that there are First Amendment rights in ranking algorithms. So he's kind of stuck with that. But he thinks that, meaning that platforms can exclude whatever they want from ranked features. And as he reads the case law, like that is more speechy because because coders write the code, because the ranking conveys a message, but regular content moderation conveys a message, very much so. It conveys a message of we disapprove of this content and we approve of this content. So I'm not sure I actually buy it. But my bigger problem with his proposal is it's just this massive waste of money to achieve nothing, right? Like if you want to have a presence on the web and to be findable, which is the only thing that his proposal achieves, you have that right now. You can set up a web page and you can be findable in Google. And the only difference in his proposal is your presence instead sits on a Twitter server or a Facebook server and like has their UI or whatever, and they're bearing the costs of hosting you, which makes it kind of spammable, right? Like I can just set up, 500,000 new Facebook accounts every day and upload, massive numbers of photos to increase their hosting costs. And I'm allowed to do that because it's my First Amendment right. So it's like burdensome and costly and inefficient, but then it doesn't actually gain these speakers anything beyond what they have right now. And it certainly doesn't get them what they want, which is to be in the ranked algorithms and prominent.
I think the thing about, there's a saying hard cases make bad law. And I think in some ways, and this is actually, Alex Abdo said this to me in First Amendment Institute, but like easy cases have the capacity to make bad law too. And like the Florida and Texas statutes are like, Jack was talking about their many, many problems. It's not even clear to me that they were really ever intended to be laws, right? I feel like the states are the dogs that caught the car on these ones, because they came out and they were political statements. They were theater. They were talking about how they were, the DeSantis and Abbott were saying all these things that are like anathema to the First Amendment about how these laws are intended to punish the liberal elites of big tech, and like we're intending to shut down these like leftist editorial choices, which are just like the most non-First Amendment-y things that you could possibly say in terms of passing a law. And so it's not, and the drafting is very lax, and there's all sort of all of these laziness. But I think so in terms of when you're thinking about it, these laws are as anathema to sort of first the animating sort of motivation behind them. It's an anathema to the First Amendment as they get. But they also do reflect this anxiety, which I think is very real, about the power of platforms, about all of these things that Jack was talking about the speech rights of users. And I fear that because these cases are sort of set up in this way, we're going to end up with some sort of absolutism ruling that forecloses more thoughtful legislative efforts in the future. I think one of the things where you read the parties' briefings and many of the amici too in these cases is it's so absolute in either direction. The states are saying there's no First Amendment interest here at all. We can regulate them however we want to. And the platforms are saying, no, we are speech intermediaries. And so we have absolute First Amendment rights to do whatever we want. And neither of those outcomes feel so great to me. I think that let's just go back to the transparency provisions as a start. It seems to me that like the First Amendment shouldn't condemn us to a world where we can't mandate some forms of transparency, some form of openness, some form of like consistency and sort of truth in community standards advertising, purely because they're speech intermediaries. And so I think that that's the outcome that I fear, is that we strike down not just these laws, but the capacity for more thoughtful future regulation.
It's funny, I would be surprised if the Supreme Court comes down with a clear and emphatic answer on one side or the other in these cases. I think what's more likely is you're going to get either this kind of mixed salad of opinions with kind of weird coalitions that will lead to an industry of law review articles on this, or that whatever they write, that there'll be so much ambiguity in it because that no one wants to be, we are giving a victory to Google here, right? I think there's enough people on there, but we'll see. We've got lots of questions that have come over Zoom, but I also want to open it up to folks in the room first, and we'll make sure your questions are really quick. I think I see 1, 2. Let's start there. Did you? Yeah. And use your microphone, even though you will not be seen, you will be heard by the people on Zoom.
Thank you. Thank you so much for your insights. It's fascinating to hear from experts on this. I have a question about when we're back to the hypotheticals of, given that these cases don't really come to the interesting lines, what would be? And Evelyn, you outlined 3 potential axes, and I have a question about a 4th, and if it's relevant or if it's not relevant, why under 230? And that would be the degree of user input that an algorithm or a platform takes into account when generating the other axes, be it the degree of personalization or recommendation. Do you think that's relevant? And to kind of put context on it, I'm thinking of the fact that the recent news report that in response to Elon's ego being hurt, Twitter has decided to change their algorithm so users are getting more of his tweets regardless of any of their own inputs. If he were to then say something that caused liability, I don't know, maybe via the SEC, is that something that, because as a third-party user, I had no say in seeing that Twitter is choosing, I'm thinking of the neutral tool language in the Ninth Circuit, is selecting this content based on who wrote it and amplifying it above all others. Is that violating 230, or is that just not even an access that 230 is concerned with?
We got a question over Zoom that's similar to this. I want to throw that also onto you, Evelyn, which is Rachel O'Connell asked, can the panel please discuss platforms recommendation engines that seamlessly connect users based on shared interests? Which I think there's a flavor of this here. For example, adults who like to view children's live streams and AI pops connects them to children via For You free feeds. I think that's sort of 1 degree separated from this question.
Yeah, I love the idea of the Supreme Court having a Elon Musk standard of liability. If you amplify an individual user times 1,000, which is literally what Twitter was doing for a few days with Elon Musk's tweets, then you become liable. Then you are recommending them sufficiently that you lose your Section 230 immunity. This level of user input is a lot of how people are trying to, or how the briefs and the thinking around protecting search engines versus other platforms is coming down to the level of active user participation, or how at what level is the user requesting the recommendation such that it's not the platform just pushing. And I think the problem with that, and I mean, Daphne's going to have more sophisticated thoughts on this than I am, but the problem with that is, like, everything a user does on a platform at a certain point is giving input, is in some sense requesting certain kinds of recommendations from a platform. It's most obvious in a search engine context. But one of the reasons why we like the platforms that we're on and the content that we get from them is because we have given lots of signals about what we like and the kind of content that we want to see. And so again, yes, that sounds very helpful, and I agree should be something that can be thought about, but it doesn't really solve the where is the line, like at what point does it become liability. But Daphne, your thoughts on that?
Yeah, I mean, I think both. I'm going to compare Facebook because I'm old with Google web search. So both of them,
which is new and
well, which people at least still use. Like half the people in the now, probably some of these people use Facebook, but in both of them, they're ranking part based on some affirmative inputs, like with web search, whether you selected the safe search filter or not, things like that, and based on some implicit inputs that are like your geographic location or your past behavior. And so drawing a distinction between like the Facebook feed is all push, you didn't ask for any of that, versus web search is all pull, it's just what you asked for, I think as a technical matter doesn't work. And if you forced them to separate, so one is only about implicit and one is only about explicit, they would both be much worse products. So I think that's hard to do. Going to the point that's come up a couple of times about connecting people. So this is a really interesting point from the dissent in Force v. Facebook, which if you don't want to read the Ninth Circuit's Gonzalez ruling, because it's like 167 pages, try reading Force v. Facebook, which is the Second Circuit's version of this case, and it tees up most of the arguments much more straightforwardly, including the dissent saying that he thought that Facebook should be liable for recommending, I think it was Hamas, recommending terrorist content and accounts. And he was quite focused on the idea that maybe the case of putting two people together is special, is different from putting a reader together with some content. And it's not totally clear why that is. He says at one point that this is all unique to the terrorism context and wouldn't apply in other tort contexts, which maybe, but like the part of the claimed harm here involves recruitment. And if this were a material support case, which it actually isn't, but if we were under the material support statute, then there's this idea of like anything you do that helps them do their thing is actionable. So there's an idea in Force that putting people together is different from putting a person and information together. This gets to the freedom of association questions that I know Evelyn has thought about a lot more than I have.
Ellen.
Thanks very much for really spectacular interventions. I'm Alan Weiner from the law school, and I focus on the terrorism and the international law part. And as my questions will reveal, I don't know very much about the First Amendment. So 2 quick questions. Number 1, it seems to me that there is consensus among the panelists that although this issue about drawing a line between publishing and recommending is hard, such a line exists, right? And it's plausible for the court to determine that there is a distinction, that there is liability at some point for platforms, notwithstanding Section 230, if they do something, and we can spin out hypotheticals all day about exactly what it would be. I'm just wondering whether we all agree that there are things that you can do that would make you liable, notwithstanding 230. And then secondly, and Professor Balkin in particular, you talked about the fact that we only have these few companies. Is there role for the public forum model as a matter of constitutional analysis, First Amendment analysis, in terms of thinking about how these cases should be decided? And I'll take my answer off the air.
You want to do the recommendation one first, and then I can talk about public forum?
Sure. So I think most of the things where I suggested it, I think there are a lot of ways for a platform to lose its 230 immunity and step outside of it. But the ones I described, none of them involved recommendations. So I don't think there's a coherent line between publishing and recommending that I can identify, but maybe there is a line based on, there's statutory language in 230 where the platform loses immunity if it's responsible in whole or in part for the creation or development of the content. So maybe if it's like the staff picks terrorism of the day list, maybe there's some point where that in whole or in part responsible line gets crossed.
Terrorist.com. I create a platform uniquely dedicated to
Well,
publishing terrorist content.
so it's funny. 2 years after it enacted CDA 230, Congress enacted the DMCA, and in the legislative history, Pam will know this better than me, but there's like, they say, what if there were a website called stolenscelebritypics.com? Would that lose its immunity? No, it shouldn't, because that anyhow. So that there is this idea in the air when they're drafting that it's very hard to cross this line.
And then on the second.
Oh, that's it. So Genevieve, like yours, is right here today.
Yeah.
And she has been thinking deep thoughts about adapting public forum doctrine to this problem. And if you want to join in, you can. I would say that public forum doctrine is not well suited to the problem. That although Genevieve will disagree with me on some points, public forum doctrine is basically about the situations in which the state must allow citizens to have access to the use of government property for the purpose of making every possible statement that is lawful under the First Amendment. Right. So in other words, there's a whole bunch of things which Daphne's called lawful but awful, which in fact is routinely left off of platforms. So that the way in which the public forum doctrine was organized was assuming that the organizer of speech was going to be a state actor and would be subject to the full panoply of First Amendment rules. But Genevieve's point is, well, maybe you should use a slightly different doctrine of the limited or special purpose or non-public forum, which might allow certain kinds of civility rules and rules that concern germaneness. So servility rules and germaneness rules are permitted in these kinds of forums, but you can't engage in viewpoint discrimination. And maybe that's the way in which you should go. I tend to be a bit skeptical about that because I think that even under the model of the limited or non-public forum, you still have things that you can't do, which platforms must do from the standpoint of what their customers need. But that's the way, if you wanted to go the public forum route, that's the way you would go. And then you'd have to solve the public-private problem, but there are lots of theories about how you solve that too.
Since you don't want to.
Do you want to intervene? Because this is something you've been thinking about a lot.
Yeah.
I'll just say that, I mean, political is capacious. And so when we talk about public forum, we usually talk about the quintessential public forum, thinking about parks and streets and sidewalks. And I think conservative politicians love to analogize the platform. This is again the weird politics that Evelyn was talking about. They love to use Marshall, Alabama, which is this case about treating a company town as a public forum that conservatives, since it was decided, hated. And they like to invoke that as an analogy to the platforms. And that would be impossible. Like you could not treat the platforms like a park or a street and a sidewalk. But there are a lot of First Amendment cases which deal with government-owned property where there is much extensive, pervasive regulation of speech, but there are still free speech interests of users that are taken account of by a ban on viewpoint discrimination. And I think the Texas law, however poorly drafted, is sort of heading, one way to understand it is heading in that direction, treating the platforms as limited public forums. But I agree with Jack that there would be significant costs. There's a lot of viewpoint discrimination that platforms do that we might think is valuable, but there are also benefits that if we are worried about unbridled discretion by platform regulators, this would limit that to some degree. And so I think it's an interesting idea. It's a way of thinking about the First Amendment where one of the areas in First Amendment law where there is some attention paid to the interests of both sides, and it's not only speaker focused or regulator focused. That's interesting.
We still have lots. We only have a minute left, and we have lots of questions that are online. But I want to end with one, Daphne, that I think is right up your alley, which is if these cases are decided against the tech companies, says someone who I think is joining us from Europe, how might that play out in light of the company's DSA obligations, Digital Service Act obligations to moderate and remove certain content under?
Sorry, is it if the platforms win or if the platforms lose?
If they lose,
lose.
well,
Okay.
do it either way. I mean,
Well,
I mean,
yeah.
how does this
Think
dovetail
about
with
the
your?
Texas statute.
Yeah.
If Texas statute is upheld, for
Yeah,
example.
so that's the main problem is if Texas is requiring them, or Florida, more to the point, is requiring them to carry speech that's actually illegal in Europe, or that actually is prohibited by their terms of service in Europe. And, I think then you get to a world where there's like major geo-blocking and geographic distinction where Canada, there's been at most a soft conflict with law, meaning one country says take it down and the other says you can do whatever you want. There haven't been cases yet where one country says take it down and the other says no, you have to leave it up. And the whole comity analysis, which is like deep jurisdiction, notary, but it would look very different in that case, and we might be coming up on that case. But I don't know what the solution is besides geo-blocking and offering very different services.
Let's end with one last question for you, Jack. You said how bad you are as a predictor with the
Yeah.
Supreme Court. So show off that incompetence a little bit. What do you think is going to happen? In
This is
Gonzalez
because
and Tom?
you want to laugh at me later?
No. I mean, so here's I'll stick my neck out,
All right.
which is I think you're going to get just a chaotic, incomprehensible set of opinions that is going to be very difficult that's going to leave a lot of options open for justices who do not want to commit at this stage to something that ideological commitments will sort of betray them down the road. And so that's my thought.
Can I characterize that a little bit? I think the other parties in these cases think maybe they're going to get Turner, meaning Turner 1, a case where the court says, here's some principles, now remand and figure out how to apply them. And what they might get instead is Denver area, a
Right.
case with 6 opinions all overlapping in incomprehensible ways.
Yeah. I mean, they've got to understand how, I think in some ways that's the worst case scenario, that
Yeah.
you can't understand what the hell that comes out of the court.
Well, so just again, I'm really bad at this.
Yeah.
I'm going to tell you. My guess is they will write a narrow opinion. The controlling opinion will be narrow. And then there'll be a whole bunch of people basically offering their 2 cents.
Mm-hmm. I
And
think that's right. Yeah.
so the other possibility is that you have an opinion that is broad, but then you'll have a narrowing concurrence, which is what happened in Bruin, the gun case. Because I think several of the justices really don't want to write a broad opinion that will make them look silly 5 years down the road. They will want to go for something that's very narrow, and they'll say all sorts of things in the course of that opinion. They'll assert all sorts of claims, which will be grist for litigation mill for later on. But that's my prediction. But remember, I'm always wrong.
It's a wonderful way to end this. Thank you to the hundreds who've joined us online and everybody in the room. Thank you, Jack, for coming in here. I'll just say for those online, every Tuesday at noon Pacific, we have our Cyber Center lunch. This week, we have one of our postdocs talking about China and digital authoritarianism. Following week, we've got Talia Stroud from University of Texas, expert on all kinds of issues dealing with media regulation or media and the internet. So please join us on Tuesdays at noon. Thanks again.